Hello friends, good afternoon and welcome to the EduSite Network. Our topic of discussion today is Introduction to Intellectual Property and its relevance in today's world, and this shall be a continuation from yesterday viewers, and as I have already mentioned, this is going to be part 2 of the lecture. And for this very discussion and lecture, we have thus in our studio our subject expert Mr. Ashwini Siwal, Assistant Professor in Intellectual Property and Data Security Laws, Faculty of Law, University of Delhi, and Mr. Siwal has been teaching since 2010. Friends, with this very brief introduction, I welcome sir to our studio and also request him to begin our today's lecture.
Thank you
for coming, sir.
Thank you. Welcome viewers. Yesterday I talked about the meaning of the intellectual property, the definitional part we covered, the object of the intellectual property, the necessity for the intellectual property, and the intellectual property regime as such superficially we dealt yesterday. In today's lecture, as Urvashi rightly mentioned that it's a continuation of the introduction, I'll be covering few more things to make the conceptual basis of the viewers. In today's lecture, I'll be talking about the historical evolution of the intellectual property. I'll be talking about the legislations, the domestic legislations in India of intellectual property, and I'm going to talk a little bit about the international instruments, the conventions and the treaties on the intellectual property. So before starting today's discourse, because as I mentioned that today's discourse will revolve on 3 points: history and the existing legislations, and the third one is the conventions and the treaties. I would like to go for the recapitulation of few points of yesterday's discourse in a small span of 2-3 minutes. So for that, you see, we understood that intellectual property is the creation of the intellect of the person. It is the offshoot of the person's intellect. When you apply your mind, you create something with the application of your mind, with the skill, with the judgment, certainly with the investment sometimes. Then you must be conferred with a right, and that right is an exclusive right, as in the case of the intellectual property rights. It's an exclusive right that is conferred on the person, which he or she enjoys for a stipulated period or a stipulated term. It is, in the case of the patents, 20 years, as I mentioned earlier in the last discourse. In the case of the copyright, it is 60 plus years. In the case of trademark, it is perpetual. It can be perpetual if a renewal fee is paid. See, this is all about the meaning. I dealt with the definition part yesterday. If you see the necessity, the object that we yesterday discussed of the intellectual property, its necessity is, it's very important to have the intellectual property regime, because with that we do what? We spurs the economy, we spurs the economic growth of the nation, and the most important part is about the necessity of the intellectual property, that it incentivizes the person, it gives a reward to the person, and with that reward the person feels more motivated to work harder, to work sincerely, and to come out with new and more advanced kinds of technologies, or say some more work which will be certainly useful for the person himself as well as the society at large. Then as far as the nature that we yesterday discussed of the intellectual property, everyone knows that intellectual property is what? Is a kind of exclusive right given, conferred to the person on his or her work. That work may be anything for that matter, but it should be certainly the subject matter, the stipulated subject matter of different legislations or different kinds of the property. Rationale, we discussed exhaustively about the rationale of the intellectual property in our yesterday's class. If you remember, we had a very exhaustive discussion on the pro-IPR rationale, wherein we covered natural rights rationale, moral rights rationale, we covered economic incentive rationale. Apart from that, in the yesterday's discourse, when we were dealing with the rationale part, we also dealt with the anti-IPR rationale, wherein we understood that there are some scholars in the academic, in the legal literature saying that intellectual property is not for good, it's not for masses benefit, it's for the benefit of one individual, or for that matter only an entity, because it caters the affluents. Only affluent can afford to own a property protection by applying to the different offices. But you see, it's, to my understanding, as I mentioned in the last class also, it's not, to my understanding, it's not clinching. I found the earlier argument more clinching and more cogent, more promising for me. With that background, viewers, will jump to today's discourse, wherein I'll be talking about the relevant legislations in India, existing in India, and certainly we will see salient features of those legislations, because in our later lectures we are going to talk about these legislations in depth, in detail, very meticulously. We'll deal with these legislations. There are nuances, intricacies. Let's have a look at the existing legislations in India. If you see, we have so many legislations in India to deal with the issue of intellectual property, of various kinds of intellectual property. As I mentioned, that there are several things that can be brought easily under the subject matter of intellectual property in respective legislations as shown in the slide. If you look, the Copyright Act 1956, a Copyright Act as amended in 2012, a off-late amendment took place in the Copyright Act in 2012, giving or facilitating many more people to own a copyright protection. I will discuss in detail about the people who all has been brought under the copyright purview recently in 2012. But before that, see, Copyright Act, if you see 57, it certainly deals with the subject matter for the copyright. It tells what all can be protected under the subject matter of the copyright. Just have a small idea about it. It's the original literary, artistic, dramatic work that can be given a protection. The cinematograph film can be given a protection. The sound recording can be given a protection. The computer program also falls under the protection under the Copyright Act. It may be very startling for the viewers that a computer program seems like a scientific invention. But viewers, see, computer program is also a copyrighted work, because it is a literary work as decided by the Supreme Court in a celebrated judgment. I'll deal with that while discussing the copyright issues and the copyright chapter separately altogether. The next legislation that we do have with us is the Patents Act 1970. Viewers, Patents Act, as the name suggests, certainly confers a protection on the inventions, because patents generally is known by the common people for inventions, for scientific discoveries or inventions or something, or some sort of amazing discoveries that people engage into. But it's not that true, because even a small novel work can be granted a patent protection. It should not always be a rocket science that can be given a patent protection. Patent Act 1970, if you talk about the salient features of this act, we have section 3, a very beautifully worded section, a very exhaustive one, detailing what are not inventions. There are so many things which can never be granted a patent protection. So what our section 3 of the Patents Act 1970 in essence is, it's a negatively worded definition. It does not provide what can be given a patent protection. It rather does what? That what cannot be given a patent protection, by telling that these are the things which are not inventions. Then with the Patents Act, if you move ahead, there is a beautiful procedure given for the obtainment of the patent. It's mandatory for the patent office to grant the patent protection within the 18 months time, stipulated time, though in the practical terms this process may be tedious, may be cumbersome, may take a lot of time, but as per the stipulation it has to be within the stipulated period of 18 months. There are several things, the salient features I am covering right now of the Patents Act, the existing legislation in India to deal with the issues of the patents. Next thing in the Patents Act, if you see, it provides a very beautiful pre-grant and post-grant opposition mechanism. If somebody does have any objection about applicant's application for the patent has not been granted yet, but say Mr. X does have some problem regarding the application filed by Mr. Y for the patent protection, then in that case Mr. X has been given a right, the statutory right, for going to the patent office and to file the pre-grant opposition. If the person Mr. X fails to do so, he can certainly do it later after the grant of the patent, and that particular opposition proceeding is called as the post-grant opposition. Let's move ahead. Let's see the Trademarks Act 1999. Viewers, the Trademarks Act 1999 is of much relevance for a common man too. You see, under the Trademarks Act, lot of things are protected. The marks, logo, symbol, sign, word, signature, smell, even the smell is protected. It may be startling for the viewers that a smell can also be granted a trademark protection. There are certain requirements, undoubtedly, the substantial requirements for obtaining the protection for the trademark. If the applicant fulfills that particular requirement, he or she can easily have the trademark protection. The very next thing about the Trademarks Act is that it's a perpetual right, viewers. Once you obtain it, you can have it forever. There is no restriction as far as the term of the trademark is concerned, or as to the point of the term of the trademark is concerned. It's a perpetual protection given to the person. It can be forever, subject to the condition that the applicant pays the renewal fee on time and gets it renewed timely. The next part that I would like to talk about is the Designs Act. The next legislation I mean to say is the Designs Act 2000. The Design Act 2000 protects the industrial designs. The subject matter of the Designs Act is what? It's the color combinations, the configurations, figures, shape, a shape given to a desk, to a chair, to a glass of water, to a bottle, to a liquor bottle, can be given a industrial design protection under this legislation called Designs Act 2000, subject to the condition that the particular application or the claim fulfills the requirement for obtaining the design protection, and the substantive requirement for the same will be discussed by me in the later lectures when we'll deal separately a separate chapter on the Designs Act later on. Then the next legislation that is in India about the intellectual property is the geographical indications of goods. Viewers, you would be amazed to know that a community right can be given, can be conferred on the whole community in the form of a GI. It's not a single person who owns a GI, it's the community right, unlike other intellectual properties which are either owned by one individual or by an entity or a corporation. But the geographical indications, by purview of the GI of Goods Act 1999, is conferred basically on the community. I would like to share one example which everyone I believe knows and certainly would be knowing. That is that we have a Darjeeling tea with us. So Darjeeling tea is what? Is a tea that is being cultivated in that region because of the soil characteristics of that region, because of the climatic conditions of that region. It has got a different aroma, different taste altogether. That particular Darjeeling GI is not owned by one individual of Darjeeling region, it's by the whole community at large, and that community shares the yield of their GI together. We'll see in the GI the procedure for obtaining the GI, the grounds for refusal of the GI, and the things on which the GI protection can never be granted or conferred. Then the cancellation procedure will look after. The next is the Protection of Plant Varieties and Farmers Rights Act 2001. Under this act, the farmers are granted or given the protection through this sui generis legislation. It's a unique legislation in itself. it does not grant a patent on a plant, because plant is not patentable under the Patents Act 1970, but still a farmer can have a protection by purview of the Protection of Plant Varieties and Farmers' Rights Act 2001 in the form of a statutory protection for a stipulated term. He can exploit it, make use of it, may make money out of it. On a plant variety, he can own a protection under this act. Then we have Semiconductor Integrated Circuit Layout Design Act. Under this layout of the circuits, integrated circuits, semiconductors can be granted a protection. Well, viewers, with this I would finish here as far as the legislations in India or the existing legislations in India. Let's take up the next part for today's discourse. It's the historical evolution of IP. When we talk about the historical evolution of the IP, the history of the IP, the first known use of the term intellectual property dates to 1769. It does not mean that intellectual property never existed before 1769. If you have a look at this historical evolution slide, it says that intellectual property dates to 1769. The term intellectual property was first used in that year, but before that, the property protection on the intellectual creations of the people was existing and it was given to the people, but certainly not in the form of intellectual property, but in some other manners. We will see those manners in our later slides and in our later discussion. Friends, if you have a look on our next slide, see, even the signatures, even on the paintings and creations, we find the signatures of the people. The antique paintings and creations which are with us in repositories, very old paintings and creations, the signatures of the makers of those paintings and creations are embedded on those paintings and creations. So what was the need? Why did they do so? Certainly with the purpose of leaving a mark on that, and certainly for the fame and recognition and for the indication that this particular creation or a painting has been created, drawn by this and that person. So if you talk about evolution of IP, we see in the history that certain monopolies used to be granted by monarchs to people in the form of latter patents, but the startling fact is that those latter patents were not conferred on the people for their creative behavior or for that matter for their creations, intellectual creations. Rather, those were granted to those people for their import activity, whatever they used to import from other nations, new technologies, new machines, new things, they used to import to their nations from other nations by traveling to different nations. So for that importation, the property protection in the form of latter patent was granted or conferred to those importers. It's quite startling that initially the intellectual property protection was not for intellectual creations or intellectual activities. Rather, it was for the importation done by the people from different countries. A latter patent used to be granted, and through that latter patent, the one who imports one particular technology to one nation, he used to be given an upper hand in the form of exclusive right to produce, to export, or say to make use of that particular importation or imported work. Then we have in the history certain other facts from where we can easily understand that the intellectual property has a history back to the date when intellectual property word was first time used. We found the stamping on the jewelry done by the people, our ancestors. That stamping reveals what? It demonstrates that There used to be a culture, there used to be a pattern where people had, certain mechanism for the indication, for sort of, identifying the goods as to who owns or who own that good, that particular good. Then in the ancient world, if you see, we had no mechanical means of copying, because no photocopying machines were there, no computers were there, no smartphones were there. The photocopying was done manually, and it was really cumbersome, really very tedious for a person to photocopy in that age. But if you see, in today's world, in the contemporary time, there's a complete contrast when a photocopying can take place in a few seconds. A person's work can be imitated in few minutes. That has posed a big problem. If you see, in the history, we had no photocopying machines, nothing like that. Then there arose a problem when we had an advent of the photocopying machines or the technology of the photocopying. Our ancestors had faced this problem, so to recover and to overcome this problem, they undoubtedly did certain endeavors to finally sort out the issue, because photocopying became a menace for them with the advent of the photocopying machines. So, introduction of the printing guilds. Some printing guilds were introduced. As the word guild suggests, that is a kind of a association or a group of persons endeavoring in one particular business together. So, with the introduction of the guilds, and the guilds were usually, rather I'll say invariably, governed by the government, and the work of the printing guilds was to keep check and balances in the photocopying. The real purpose of the printing guilds were not to let any copy of any person without authorization of the printing guild. The prior permission of the guild was necessary. So they used to decide what could be marketed, what could be produced, what could be imported, what could be manufactured in the form of photocopying. It was their privilege, certainly their privilege. The guild's privilege, I mean. If you go little bit down into the history, we had the instances in the form of some measures taken by the European states in the form of censorship and privileges. In the European Union, when the people started facing the difficulty with the advent of the photocopying machines and the technology of photocopying, they derived the mechanism of censorship and conferring of certain privileges to few people, a chunk of people. Censorship for the purpose of keeping a check and balance on the activities of the people. It was an era when you see a lot of disturbance was going on. So this tool was even used for the political expediency. This tool in the form of censorship was used for their personal vendetta and personal aspiration. I mean the personal aspiration of the government. Then we had monopolies to the importers. As I already discussed, that letter patents used to be conferred on the people who used to bring something or import something to one nation from another nation. The first thing that we see in the form of the establishment of the stationers' company in the 16th century. It's quite startling that they established this stationers' company in 16th century, not from the point of view of the intellectual property, but if you see, this measure was initially brought not for the purpose of intellectual property protection, prevention or safety. It was rather a political expediency, because with the 1556 establishment of the stationers' company in England, in UK, The purpose, the aspiration of the government was to stop the Protestant movement so that there does not take place any dissemination of the literature against the government. That is how, they used this stationer's company in the 16th century. But it is for the intellectual property history that we are seeing it. Then there was a statute of monopolies passed in 1623. Then the first licensing act in 1640. The next thing in the history, if you see, that's the important statute of Anne in 1710, granting an initial 14-year protection period and a possible 14-year renewal. So, in the year 1710, with the statute of Anne incorporation, a span was determined, a term for the intellectual property was determined, that it will remain for 14 years with the person, and renewal is also possible. Then we go down the line in the history, we see US patent law was enacted in the 1790 as part of the constitution. This was signed by the George Washington on July 31st, 1790. If you see, in the United States, the first Copyright Act was passed in 1790, which contained most of the principles of the English law. Let's come to the history in Indian scenario, in India. In India, first Copyright Act was passed in 1914. Patent system in India was first introduced by British government in 1856. Indian Patent and Designs Act was there in the year 1911. After that, post-independence, we had a lot of acts dealing with several intellectual properties separately. Copyright Act, as we have seen, the Trademarks Act 1999 we have seen, the Patents Act 1970, Geographical Indications Act, and Industrial Designs Act, Geographical Indications Act, Semiconductors Layout Designs Act. So there are several legislations in India to tackle with the issues posed, challenges posed by the intellectual property and related issues of the intellectual property. This intellectual property has become buzzword in the year 1994, 1995 you can say, when we had signed TRIPS. All the member nations of the TRIPS were bound as per the TRIPS stipulations to make certain changes into their domestic legislations in consonance with the mandates of the TRIPS, and they did so because they became the signatories of the TRIPS. But TRIPS, as I mentioned, or with the inception of the TRIPS, as I mentioned, intellectual property has taken a different dimension altogether, because you see, it became a buzzword after that. It was a most comprehensive treaty. It was all encompassing in its essence, in its spirit. It covered all kinds of intellectual property. It did not deal only with the one individual kind of intellectual property. It dealt with all kinds of intellectual property and provided the enforcement mechanism for the intellectual property. So with that, you see, I just wanted to tell, in the history we had these many events to see and track in so far as the intellectual property history is concerned and the evolution of the intellectual property is concerned. We'll talk about the TRIPS certainly in a very exhaustive fashion when we'll deal with the issue of international instruments, conventions, treaties. The next thing that we're going to have in today's discourse, the third part of the today's discourse, is need of international conventions and treaties. Friends, you must be having these questions in your mind, that why did there arise need for the protection of intellectual property? First thing, why did there arise need to have international instruments conventions, treaties on intellectual property? These are the questions to be answered and to be understood at this juncture, because these questions are very important to make your conceptual basis of the subject. See, international conventions, treaties are very important for the intellectual property, because all the nations, the member nations, the signatory nations of various conventions and treaties, they abide by the tenets of these several treaties and conventions. Out of several treaties and conventions, the TRIPS is the most comprehensive one, is being followed by maximum nations, is being complied by maximum nations. When we talk about the international conventions, the treaties, we have two separate sets. I would like to introduce the viewers at the outset. One set of the treaties and international instruments is a set where we see WIPO administered treaties. World Intellectual Property Organization, a special agency of the United Nations, which deals with or which administers certain treaties, certain conventions to deal with separate kinds of intellectual property, several kinds of intellectual properties. WIPO administers treaties. The next set of the conventions and treaties are some other treaties which are not WIPO administered treaties, rather are the treaties administered by World Trade Organizations. TRIPS, for example, is a treaty administered, organized by the WTO. Then we have other treaties in that lining. We'll take up all those treaties one by one. Let's have a look as to why there arose a need to have these treaties and conventions. Friends, the first question, what prompted the need of conventions and treaties at international level? Why there arose a need? The two answers I would like to attribute to this question. One, because of the inadequacy of the regulations and laws, legislations relating to intellectual property. The second reason I would like to attribute, or our answer that I would like to attribute, is there was a complete absence, complete ignorance, absence of the laws relating to intellectual property in many nations. When we talk about the inadequacy, many developed nations did not have full-fledged, all-encompassing intellectual property legislations and regulations before TRIPS. And so was the case of the developing nations. And in some least developing nations, there was a complete absence of the regulations, laws relating to intellectual property. That paved the way, or paved a platform for having a robust international instrument regime, so that in the developed as well as in the developing nations, we can have set of laws dealing with the intellectual property issues, regulations dealing with the intellectual property issues. If you see, in the international conventions and treaties, there is a long list of the treaties that will take up in two different sets, as I mentioned in the talk, that WIPO administered and separately administered treaties. The next question, what are the important conventions and treaties? As I mentioned, that we will see WIPO administered conventions and treaties and the separately administered treaties by, say, WTO in the form of TRIPS. The next question that must arise into the mind, what are the important features of various conventions and treaties? I'll gonna take it in a very beautiful manner. The salient features of various conventions and treaties I would like to put across here in front of the viewers. The salient features I'll be covering, because it's not really possible, seeing the paucity of time and the other constraints, to see the things verbatimly of all the treaties, but the salient features of all these treaties I'm going to cover in today's discourse. Then we have another question. After having a robust international treaty regime or conventions to deal with the issue of intellectual property, in this contemporary time, do we have a full-fledged, all-encompassing regime in our nations to tackle the issues of intellectual property? Or the question rightly framed in this slide, that how far the existing conventions and treaties are successful in attaining their intended object. As I mentioned, that their intended object was to bring the uniformity, the adequacy, and to bring certain laws in the nations where the laws relating to intellectual property were non-est, were not existing at all. So are these conventions, are these treaties successful in attaining the aim, the desired aim, the intended aim, the object? That would also be dealt by me in the today's discourse. Let's have first of all a look on the factors prompted international conventions and treaties. There are 3-4 things that I would like to attribute in this slide as to the point, what are the factors prompted international conventions and treaties. As I mentioned, there are 2 prominent factors as I attributed, one the inadequacy, the another absence, and the third one I would like to tell you is that there was no uniformity on intellectual property rules and regulations and legislations world over. But there are some other factors that also prompted the need for the intellectual property regime, or say conventions and treaties. Let's have a look. These are, if you see this slide, these are kind of a problem in this slide. It's not visible to the viewers. That there are certain factors attributed by me in this slide, as they are not visible in this slide, but I would like to tell you orally the factors. One is the extraterritorial application of the intellectual property. You see, to determine the territory of the intellectual property is not possible. I mean, as I mentioned in yesterday's discourse, that it's a temporospatial right. It means it's a right which is limited in terms of time and space. With space, I mean territory. But what about if somebody wants to own an intellectual property protection in some other nation? A national of America wants to own a property protection on a patent, or say a protection in the form of a patent on his invention in India. Can he be given? In today's time, it is possible. But when we had no conventions or treaties exclusively dealing with the issues relating to intellectual property, it was really impossible for a person. I'll tell you why. I'll tell you why by giving you a good example. Suppose an Indian inventor having a very good inventive work, qualifying all the requirements in India for obtaining or fetching a patent protection, goes to some other nation. I ask the viewers to just listen it in a hypothetical manner before international conventions and treaties. Not now. It's possible in today's world to have patent protection in many nations in one go. You see, in one go one can have patent protection in many countries. But it's a scenario which I am assuming pre-conventions or pre-treaties. Right? Let's come back to the example framed by me. An Indian inventor owning a very good inventive work, qualifying all the requirements in Indian situation for fetching the property protection, goes to some other nation. He bewilders when he sees that there are different requirements altogether for owning a patent on his work in that country. It will be impossible for him to own the protection. The next thing, the next challenge, the difficulty that he may face over there, his work can be a subject matter for the protection in India, but cannot be a subject matter of protection in another nation. A second difficulty. The third difficulty is that the process of obtaining the patent protection in this example in several nations may take a lot of time, lot of energy, lot of money, because he has to move in person to different nations at one point of time simultaneously, which is humanly impossible. You see, he cannot go to different nations at one point of a time. He has to appoint several people, several attorneys, by paying them exorbitant fees, right, by preparing for the papers or for preparation of the application specifications. Respective specifications and procedures are to be followed by the attorneys or by his proxies in many nations, which is humanly impossible. So see, in the pre-convention era or before uniformity era, these were the challenges faced, and these challenges, especially this territory related challenge, prompted the need of having the international conventions and treaties. The another factor attributed by me, especially about this issue, that what prompted the international conventions and treaties, the need for having the international conventions and treaties, is that we had no uniformity at all. Even the basics of the intellectual property used to differ from nation to nation, from one boundary to another boundary. That was a big challenge, because it's really impossible, as I mentioned in my earlier example beautifully, for a person to go to several nations and own a protection on his work. And it's not only with the patent the problem was lying, it was with all kinds of property the problem was there, be it a copyright or a trademark or whatever for that matter. So there was a need to formulate or frame some basic tenets, some common tenets for all the nations, for all the signatory nations. For example, you see, if one individual wants to have a protection on his work, and he wants to have it in many nations, so that he can exploit it in a very good manner, properly, in all potential manners. So for that he needs to have a protection in many nations, right? It's not possible, it was not possible because of the lack of some basic tenets, or say because of the lack of some common basic tenets in the domestic legislations of the nations. Today, if you have a look of the legislations of several nations, not only of India, you will find that there are some common features, some basic tenets. For example, a tenet in the form of national treatment to be given even to the nationals of other nations. A tenet wherein similar subject matters, not exactly similar, but kind of similar subject matter you will find in different nations. Similar procedure to an extent, not completely similar, but to an extent it would be similar, because they'll have to abide the basic tenets or comply the basic tenets. So that was also one of the factors that prompted the need of having or going for the international conventions and treaties. The another reason, there used to be a pattern, pre-convention time I am talking, there used to be a pattern where discrimination used to take place for the nationals of other countries. If some national of America comes here in India and wants to own a property protection on his work, he used to meet the discrimination in the procedure, in the payment of the fee, in many other aspects. But that's not true in today's case, in the contemporary time, because now we have a set pattern, a complete uniform pattern, almost uniform pattern, wherein all the nations are complying with the international instruments and international conventions and treaties and has incorporated into their domestic legislations some basic tenets, which has made the domestic legislations quite easy for the user, or say for the inventor, for the person willing to own a property protection. These are some conventions and treaties, and the salient features of these conventions and treaties I would like to put across to the viewers. If you see this Paris Convention of 1883, it was on industrial property protection. Paris Convention of Industrial Property Protection, or Paris Convention protecting the industrial property of 1883. It recognized only two kinds of the properties. It did not deal with all the kinds of the intellectual properties. Today we have 8 kinds of intellectual properties recognized by the TRIPS, which is the most comprehensive treaty. But the Paris Convention of 1883 recognized only 2 kinds, the trademarks and the patents. As the word industrial property suggests, that they dealt in the Paris Convention only with the industrial property, not with the other properties. That is why patents and trademarks were squarely dealt by the Paris Convention 1883, and we do have certain features embedded in our domestic legislations of the Paris Convention. Even the TRIPS has some reference of the Paris Convention, because generally the TRIPS is being followed and complied in all the nations nowadays. Then we had Berne Convention of 1886. This Berne Convention was on literary and artistic work. It was not on the industrial property, the way the Paris Convention was. Berne Convention dealt only with the literary and artistic work. So literary and artistic work, as the viewers know, are copyrightable subject matter, can be given a copyright protection, not the patent protection, not the industrial property protection. So Berne Convention 1886 will see the salient features of the Berne Convention. The TRIPS agreement. TRIPS stands for Agreement on Trade Related Aspects of Intellectual Property. As I mentioned, that it's a most comprehensive, expansive treaty, wide treaty, all encompassing in its nature, in its essence, covering all the intellectual properties. We'll see its origin, its inception, the reasons of its inception. As the caption rightly suggests, that it's certainly going to deal with some issues relating to trade, because TRIPS stands for what? TRIPS stands for Agreement on Trade Related Aspects. Trade related aspects. Why I am emphasizing on this point, that it's an agreement on trade related aspects? Viewers, there was a problem going on in the trading of the properties having some intellectual property features. So to overcome with those problems, to preclude the challenges, they came up with the TRIPS. It's an offshoot of the GATT, General Agreement on Tariff and Trade. We'll see the salient features of the TRIPS. Then we had a WIPO Copyright Treaty 1996. WIPO, as I mentioned, WIPO stands for World Intellectual Property Organization, a special agency of the UN. It administers many treaties. There are several treaties that I'll deal with. Then the Universal Copyright Convention, Rome Convention. Then we had some conventions relating to plant varieties, some conventions relating to integrated circuits. I'll be covering all those. Let's have a look first of all on the salient features of the Paris Convention. It accorded the right, the first important right of national treatment in each of the member countries. Viewers, let me elaborate it a bit, this right in the form of national treatment. As the name suggests, national treatment means that every signatory nation will give a national treatment even to the nationals of other countries. There would not take place any kind of a discrimination, and no discrimination will be acceptable at all in the form of asking him to pay some extra fee, or say going through a different procedure altogether for obtaining intellectual property, or say subject matter issues. So national treatment simply refers to similar treatment to be given to the nationals of other nations. First thing that the Paris Convention did in 1883, that it accorded the national treatment principle. The next thing, that it establishes another basic right known as the right of priority. It's a very important right. The viewers must understand the right of priority. The right of priority means, if you file one application for obtaining a trademark protection in your country, and you want to own a trademark protection in other countries also, you will be given a priority over others. What does it mean? Let us take it through an example. Mr. X files a trademark application in India for obtaining a trademark on his subject matter. He wants to have a similar word protected in other nations. He goes to other nations, files the application. His application will be termed as a priority application. What does it mean? As if he had filed on the prior date, no matter, notwithstanding that he went to another nation after 6 months down the line, but still he will be given the priority, as according to the Paris Convention on the industrial properties, a trademark or a patent for example, priority right has been accorded, has been conceded with. We will have a priority right discussion again when we deal with the TRIPS. The third thing that this Paris Convention accorded, the third category, that it came out with certain common rules in the field of substantive law, common rules for the patents, for the trademarks, to be followed by all member nations, those who are signatory of the Paris Convention. These are some of the salient features. Verbatimly, the whole treaty cannot be covered in the lecture. The next convention, important convention, is the Rome Convention for the literary and artistic works. The subject matter of the Rome Convention is altogether different. It's the literary and artistic work, unlike the Paris Convention. In the Paris Convention, it was trademarks, the patents, the industrial properties, I mean. But here it's the artistic and literary work. You see, it is also based on the principle of national treatment. This convention, through its article, speaking through its article 7, spells out the protection of neighboring rights. It even accorded a protection on neighboring rights. Does not only give a protection or say, provided a protection to the literary and artistic work, rather on the neighboring rights of these works. I'll tell you what does this neighboring right mean, but not now, when we'll deal with the copyright as a separate chapter altogether. It provided a protection to performers, producers of phonograms and broadcasting organizations. An important thing to be noted and to be seen by the viewers, that it accorded a protection to performers. See, with the Rome Convention, a protection was even granted to the performers also. Then you see, it has been not revised yet, and there was no need because there came a TRIPS after that. Then we had a patent cooperation treaty. It's a very good treaty, relating to the patents. It's an agreement for international cooperation in the field of patents. It does not compete with, but in fact complements the Paris Convention. What does it mean? That it is just complementing the Paris Convention, the tenets of the Paris Convention. It's not supplanting the Paris Convention, not stifling the Paris Convention, rather complementing it. Well, viewers, for today we'll finish here. I rest here today, and I'll continue tomorrow with the same issue. Thank you very much.
Thank
all
you.
the viewers.
Thank you. Thanks a lot, sir, for the very interesting lecture that we had. And of course, as you have already mentioned, we are going to take up this further and continue this in our next lecture. So, friends, we'd like to take your leave, but we must thank sir for being with us today. Thank you so much, sir, for coming and being associated with us.
Thank you.
And again, thank you, friends. Keep watching. Have a wonderful day ahead.